I'm just going to record this presentation for anybody who isn't able to make it today. But we are excited to go over a presentation over change orders. Joseph Muniz, one of our associate attorneys at our San Antonio location, will be presenting today. Change orders is probably one of the most common things that contractors deal with consistently, but it's actually one of the most common roots of disputes that we see in our office. So we're going to go over today kind of common pitfalls and certain things that you really should be looking out for and working on to protect yourself from potential disputes later on. So I am going to go ahead and hand it off to Joseph.
Thanks, Jackie. Thank you all for joining us on your lunch hour. As Jackie said, we're going to talk about change orders, some of the common pitfalls that contractors face, and hopefully give you some tips to avoid any unnecessary disputes and avoid some litigation costs. So why don't we jump right into the slides. All right, so if you're in the construction industry, you know that change orders are pretty commonplace. No matter how much planning goes into a project, you can't foresee everything, and there's going to be issues that arise where you need to change the project itself or just amend what the scope of work that was agreed to. A lot of times the owners or the GCs initiate this, or sometimes you the subcontractor have to initiate it when you recognize that the potential issues. If we can move to the next slide. First, let's talk about what a change order is. It's a written form that details the change in the scope of work that you agreed to in the contract or the bid. Now, that could be a removal of some of the work, or more commonly, it's an addition to. And that change order becomes an amendment to the original contract, and the owner, GC, and the subcontractor have to abide by that. If not, then a breach of contract cause of action may arise, and that's where it gets kind of expensive and complicated. So let's talk about some of the common mistakes. One of the most common mistakes contractors make regarding change orders is not adhering to the change order protocol in the original contract. Now, most construction contracts contemplate that there's going to be issues that arise during the project itself, so they do provide guidelines or procedures to create a valid and enforceable change order. Some of these are complicated, some of these are pretty straightforward, but it's really important for contractors to have a firm understanding of the procedures before you sign that contract and before you start to work. Because the last thing you want to do is get in the middle of the project, an issue arises where you need a change order, and you just kind of do it on the fly, and you don't follow the set out procedures. If you do this, you run the risk of not getting paid on the change order because it may be found invalid or unenforceable because you didn't follow those procedures. Now, how common is this? It's probably more common than you think. A general contractor or owner, if they can find a way to get out of any additional costs, they'll move on it. So you want to make sure that you know what the procedures are and you follow them to a T. Another common mistake is performing the work, the change orders, without having it in writing. Now, we all know that change orders, they do arise while you're on the project, and the GC may say, hey, look, this obviously needs to be done. Can you get it done? We need it now. Of course, you're not going to sit there and get on your notepad or something and write down the change order details. Usually you get the job done, and then you request the payment or the change order. But our tip for that is, even if that it is commonplace for that to happen, you want to be cautious and you want to follow up after the work's performed with a summarization of the work that was performed in writing. You want to detail what the project is, the date, the details of the work to be done, the cost involved, and any change in the timetable for completion of the overall project. Now, I suggest that you send this immediately after the work's done, or reasonably after, and send it in two different forms. You can send it via email, and then additionally, you can do it via text or a certified letter. But you want to make sure you're proactive and get this to the other party as soon as possible. You know how fast construction moves. The last thing you want to do is down the road having the GC say, I don't remember agreeing to that, or that's not what took place. So document everything and be as detailed as possible as soon as reasonably possible after the work is performed. Okay, so now we're talking about the scope of work. Where this comes into play is, okay, so you put in the bid, and then if you award the bid and you sign the contract. First, you want to make sure that the contract you signed has the scope of work you agreed to in the bid. It may not always be the same, but that's what you're going to be held liable for, what's in the contract. So you always want to have a sound understanding of what you're agreeing to and what you're not agreeing to, because that's going to determine what is a change order and what is not a change order going forward. So again, before you sign that contract, make sure you go over it with your staff, and make sure you have a good understanding of it. Now, once you've established what is within your scope of work, that's where change orders become, essential. You have to understand what's outside of the scope of work and what was already considered. And that's what is called extra work versus additional work. Now, extra work is what is not considered the scope of the original contract, and it's outside of it and independent. Extra work is where you need a change order. Now, additional work is work that was already considered within the scope of the original contract. It may not say it, specifically, but that work is necessary to get the original scope of work done. Now, this is where it gets a little complicated, because different parties will have different perspectives and classify the work accordingly. So when you have an understanding of what your original scope of work and these issues arise, you really want to make sure that you distinguish which classification is before you actually work or perform the change order itself. If we can go ahead and move to that next slide. So what we're saying here is the classifying it becomes a contested matter because of the different perspectives. If you're an owner or a general contractor, you're going to take the perspective of its additional work, because obviously they don't want to have any additional costs involved. They're going to say that it was part of what you already agreed to in the original contract. Now, from a contractor or a subcontractor's perspective, of course, you're going to want fair pay for additional work or extra work. So you're going to want to take the perspective of it was not contemplated in the original scope of work. This is in addition, there's additional cost involved, and you need to have a change order for that. Again, these need to be established before you start the work. Otherwise, you're going to be down the road and you're going to have this argument, and you may have a dispute where a lawsuit's necessary. And a lot of these general contractors, they have legal staff in-house, and they know they'll do the cost benefit analysis. They know if it's a $2,000 change order and there's some issue with its validity, it'll cost the subcontractor more than the $2,000 that's owed just to resolve the dispute. So they may give you a hard time knowing that it's going to cost you attorney fees well over and above what the actual cost is. So this is why it's extremely important to be proactive early on in the early stages of the project, and before the contract is signed, and before you perform these additional or extra work. We talked about the different positions and how the importance of knowing which classification is before. So a lot of questions I have is, of course, does it need to be the change order? Does it need to be in writing? We've kind of discussed it doesn't have to be in writing, but it should be. If you can't get that signed and agreed to beforehand, you need to follow it up. I believe we included an example of a change order with these slides. I'm not positive, but again, most of these contracts contemplate these change orders and have standardized forms that they require you to use. If they don't, you can look at the sample template that we have. It's pretty general, but again, it all comes down to the details. You want to add everything possible. If you're like you have too many details, there's nothing wrong with that. The last thing you want to do is have any question marks when you're trying to collect on a change order. Here's a little details about, again, what should be included: a clear description of the requested change compared to the original contractor bid, the itemized cost involved, a summary of the total cost of the proposed change, a statement regarding the impact of the project completion date. If it's going to take you another week, you want to make sure you document that. That way down the road, you're not looking at delay charges or any question marks when it comes to the timeline. Just summarize the promise of payment. That way, you're strengthening your case if down the road you find yourself in a dispute. So how can you protect yourself? Again, be as detailed as possible with change orders. Don't be intimidated or afraid to include probably more than you may think you need. Most contracts place the burden on the contractor, even if the general contractor or the owner says, look, this is what we need to get done, here's the change order. A lot of times it falls on the subcontractor or contractor to initiate the official process and follow the procedures. Although they instructed you to do it, they give you the details and maybe even the cost involved, you need to make sure that you send it to them in writing, like I said, in multiple methods, and to make sure that you follow their procedures. I think that's it for that slide. Just to summarize, change orders are commonplace. It's a simple concept, but there are issues that become more complex down the road. We've given you a few tips. Again, it really comes down to being proactive in the beginning and doing your due diligence. Make sure that you're aware of the scope of work that you're agreeing to. Make sure that if there are change orders necessary, that you get them in writing and that you agree to them before the work is performed. If not, it's not a lost cause. It just makes things more complicated. And construction projects are already complicated as it is, so you don't want to add to that. And if you're ever confused about the contract itself, of course, I suggest getting an attorney to review it. I always say that, the general contractor or the owner hired an attorney to write it. You might as well hire an attorney to read it and interpret it. But that's all we have over change orders. So I guess we'll take some questions, Jackie.
Yes, yeah, thank you, Joseph. We're going to open up for questions for the rest of the presentation. If you're on the computer, you can send your question via the message and I'll read it out, or you can unmute yourself if you're on the phone. So go ahead and start sending those questions in. Cheryl asked, where can we find the change order template you talked about? That is in the handout that I emailed out to y'all before the presentation. It was, I think, the last page of that handout. I'll also follow up this call with an email to all of you with the presentation and the template as well.
And again, if the project has a template already given, make sure that you use the required template and not an outside source like ours. If they don't have one, then you can use something like that we're providing.
All right, Victoria's got a question. What could a sub expect to pay an attorney to review a contract for them?
That would kind of be determined on the size of the contract. Some of them are simple and straightforward, and it won't take us too long. Some are more complicated. And Jackie, I think we have pricing involved, don't we?
Yeah, we have some flat rates available. So if you have contracts that are under 35 pages, we've got flat rates between 550 and 1,050, depending on if it's a 10-page contract, a 20-page contract, et cetera. So you know, usually under $1,000 with a general retainer with us, it's going to be just based off of the hours taken to review each contract. So that would all kind of depend on the length, but typically most contracts that we see from subcontractors are 500 to 1,000. Yes, and Victoria, much less than a lawsuit. So it definitely is, you know, much better to make sure that you're not signing anything that's going to kind of risk your ability to take action or collect, you know, for things that you are owed later on, making sure that you're not signing your rights away kind of when signing some of those contracts. So it's always very good to have them review.
Yeah, and a lot of these contracts, you know, the general contractors feel that they have all the leverage. In many cases, they do. So they send these out to subcontractors, you know, with the thinking that, you know, they can't change the terms. It's take it or leave it as is. That's not necessarily the case. There's nothing wrong with trying to modify the contract, asking questions. The worst they can say is no, and you move on. But even besides that, what you really want to know is what you're getting into. What are the potential pitfalls? What are the dangerous clauses? That way, when you're going into the project, you can kind of, you know, guide your behavior based on the risk factors involved. So you have to know the risk factors when you're going into this. The last thing you want to do is see that there's some clause that you weren't aware of, that you didn't read, and now every sub's getting sued by the GC or owner just to increase or to improve their bottom line.
All right, thank you, Joseph. All right, any other questions? Like I said, this is also a good time if you have a specific example in regards to change orders, whether you're, you know, in the front end or if a dispute has already started based off of a change order. So we've got one more question here. They're asking, do change orders have to be paid in advance?
No, they do not have to be paid in advance. Generally, they're not paid in advance. Again, they become they become a part of the contract. So it really depends on the payment terms that you agreed to. So if your project was for, let's just say $1 million and the change order makes it to $1.2 million, then the payment terms would still apply to the change order. And also your lien rights, they would also apply to the change order and the time that it took place. You always want to make sure you preserve your rights, your lien rights, and do the proper notices based on the timelines, the statutory timelines. If you miss those deadlines, it gets a lot more complicated, and you kind of lose your best method of getting paid.
Thank you, Joseph. And I kind of have a question on a little bit of what you said. So if you fail to get the change order in writing, and at the end of the project, you're ending up having to file a lien or, you know, use your lien rights. If you don't have a change order in writing, does that kind of mess up your ability to collect that portion?
Well, as long as you send out again, something in writing, you don't have to have the actual change order in writing, but you need to send out the invoice for the work that you did, and then you can base your lien on that invoice and the timelines when the work was performed. And even if you miss out on your lien rights and you don't have it in writing, I mean, it doesn't mean that you don't have any more causes of action. You can still pursue quantum merit or unjust enrichment, meaning that the other side benefited from your work and it was reasonable for them to understand that you were going to collect payment on it. It's more of a common law way. So to get around if you don't have something in writing, you can still go after them for what you're owed.
All right, thank you. All right, if you've got any other questions, you can unmute yourself if you're on the phone, or if you'd like to send it via the message chat, you can do that as well. All right, so we've got another question. Can a change order be created by the contractor on the basis of necessity of the project without the consent of the owner? So, you know, if they run into something, this has to be done for them to be able to move forward, can they be the one who is initiating it versus the owner or the GC?
Yeah, it's possible. Again, every contract kind of contemplates these, and there's some rights that are given to the general contractor. A lot of owners aren't, you know, as on top of it as others. So the general contractor may have the authority to enter into change orders. So you know, if the general contractor, you know, signs that change order, you sign that change order, they would be liable, and you would still have lien rights because you're doing improvements to the owner's property, who ultimately will be liable.
Okay, thank you. That was a good question. Any other questions? All right, well, if we don't have any other questions, we'll go ahead and wrap up the call. I know everyone's got busy days and a lot going on. I will send out an email to everyone with the presentation that was gone over, the change order template, as well as Joseph's information if you'd like to reach out to him for anything further. All right.
Thank y'all.
Yeah, have a good rest of your day. Thank you.